IPR or intellectual property rights is one unique area of law wherein there are lots of career options for persons with strong scientific domain even though such person is not an advocate. In R&D and innovation driven industries like automobile, pharmaceutical, biotechnology, automotive, there is always a good demand for professionals who are graduate or postgraduate in science. I've got many requests to make a video on careers in IPR for advocates who do not hold degree in science. I'm Bindu Sharma from Origin, and in this video I will list out some of the career options in IPR for advocates. As you know that intellectual property refers to creation of mind such as inventions, designs, name of the product or services, literary, artistic work, etc. IP is protected by law in the form of patent, trademark, copyright, design, traditional knowledge, geographical indication, trade secret, plant variety and farmers' rights, and semiconductor chipset design, etc. So, IPR is a kind of legal right provided by the government for creation of human mind provided such creation fulfills certain conditions. Based on the type of IP, it can be registered under right legal framework. IPR is probably one of the very few subjects of law wherein lots of professionals with science degree like engineering, biotechnology, chemistry, pharmaceutical, artificial intelligence, machine learning, etc. are seen to be doing quite well. Certain areas of IPR like patent law requires a person to have a sound knowledge of science because patents primarily relate to hardcore technology, inventions and related work. Due to ability of science students to understand technical aspects of technology or the invention, most of the companies prefer them over advocates specifically to perform tasks like patent search, drafting, filing and prosecution of patent applications. It is interesting to note that in order to file patent application on behalf of the client in India, it is important for a person to be registered Indian patent agent. Registered patent agent is a person who is at least graduate in science and has cleared Indian patent agent examination and further has registered himself as registered patent agent with Indian Patent Office, and patent agent may or may not be an advocate. Please note that a person who is registered as an advocate with Bar Council, but if such advocate is not a registered patent agent, he is not authorized by the patent office to act on behalf of client to draft, file, prosecute patent application in India or PCT. The list of registered patent agents is published on official website of Indian Patent Office. Patent attorney and patent agent. These are the two terms used often in the industry. It is important to understand difference between the two clearly. Patent agent is graduate in science and he does not need to be an advocate. In order to register as patent agent, Indian patent agent exam has to be written and cleared. This examination is generally conducted by patent office once in a year. On the other hand, patent attorney is an advocate who practices IP law and he may or may not be a patent agent. Patent attorney shall be registered with Bar Council of India as an advocate. And here patent attorney can write Indian patent agent exam only if he is graduate in science. Patent law happens to be a lucrative area to work in and an advocate, if he is not graduate in science, is not eligible to write Indian patent agent exam. This leaves a very big question mark on what are the opportunities left for advocates to practice in IPR, especially in patent law. I will try to put some light on career opportunities for advocates in IPR. After a patent application is filed, it is published after expiry of 18 months from the date of filing or the priority date, whichever is earlier. On specified grounds after publication, application may be opposed by anyone as pre-grant opposition. Within 12 months after patent is granted, any person interested can oppose the patent as post-grant opposition. Further, after this 12 months period after grant of a patent has expired, the process to invalidate a patent is called as revocation of patent. An advocate without being a patent agent can very well handle such pre-grant, post-grant oppositions, revocation of patent before the controller of patents or IPAB, Intellectual Property Appellate Board, as the case may be, even though it may get little complicated due to technical nature of patent specifications, but opposition and revocation certainly can be handled by an advocate. As we discussed that patent specification drafting, filing and prosecution is something that has to be done by registered Indian patent agents, but there are lots of other areas to practice in for advocates. Patent or IP audit is required to be done at the time of acquisition and merging, where there may be a need to check legal status of patents and docketing the same for upcoming deadlines, calculating renewal, etc. And advocate can undertake IP audit very comfortably. Valuation, commercialization of patent is need of the hour, and advocate has vital role to play in this. At the time of technology transfer, negotiation, drafting technology transfer agreements may also be required to be done by an advocate. After a patent application is filed, docketing of patent cases and coordination with foreign attorneys regarding foreign patents is required by most of the law firms, and this can be very well undertaken by an advocate. Further, in order to assess and mitigate patent infringement risk when a new product has to be launched in the market by the companies, there are specialized kind of searches like infringement analysis or freedom to operate search. And here, even though the search is performed by the patent agents, but interpretation and writing opinion is required to be done by the advocate. In case of infringement opinions, advocates they have vital role to play in terms of claim interpretation and referring to right statutes along with the case laws. In fact, several companies require such FTO reports or infringement opinions to be signed by the advocates. Another lucrative area in patent law for advocates is patent related disputes like patent infringements or litigation. Further, portfolio management to look after legal commercial strategies, enabling planning regarding portfolio creation and management, licensing. The technology is also a very potential area to practice in for the advocates. Now, after patents, let's have a look at the career options for advocates in the area of trademark law. The number of trademark applications filed in trademark registry are far more compared to patents. In fact, the disputes, infringement cases, and related litigation matters are also very high compared to patents. Due to this, trademark becomes a very potential area for advocates to specialize in. For non-advocates, it is important to be a trademark agent to file and prosecute trademark application. However, being an advocate, there is no need to be trademark agent. The scope of work in the area of trademark includes advising clients on selection of trademark for new products or services, trademark search to give opinion on strength of the mark, and after the search has been done, then preparing, filing, prosecuting trademark application in India and Madrid, handling opposition, disputes, and litigation. So there is huge scope of practice for advocates in the area of trademark law, and it's worth considering trademark law as good career option. Other than trademark and patents, there are other forms of IP such as copyright, design, geographical indications. And as an advocate, all areas are open for you, and you can practice in all other areas of IP as well. And you can undertake the work of registration of such IPs like filing application, prosecuting, and enforcement of IP rights in these areas as well. So, this broadens the scope of practice to a very large extent. So, overall, for the advocates, IPR is a very potential area to practice in. Although it has to be understood clearly that an advocate is not authorized by Indian Patent Office to draft, file, and prosecute patent application in India or PCT, but there are numerous other opportunities for advocates in other areas of patents, then further trademark, copyright, geographical indication, etc. So all these areas are open for you to practice in as far as IPR is concerned. So if you have any questions related to the career options in IPR for advocates, you can type your questions in chat box. I will try to reply all your questions, and I hope you found this video useful. Wish you all the best. Thank you for watching this video. I hope you found it useful. If you have any queries related to our services, you can contact us at the email ID and phone number provided in this slide. Thank you. Have a good day. Take care. Bye bye.